Okay. Good morning, everybody, and welcome. It's Thursday, September the 25th. We're in Austin, Texas for today's meeting of the Texas Low-Level Radioactive Waste Disposal Compact Commission. And I see Mr. Salzman is here, Judge Dolgener is here, Mr. Hurley is here, Karen Watkins, our lawyer, is here, Linda Morris is here, Dick and Peter from Vermont are both here. Lee Ing is present, Audrey is present, and we have a number of distinguished visitors and guests, first of whom is Representative Burnham. Representative Burnham, good morning. I don't know that there are any other elected officials present other than the judge, of course. He's always here. And I don't know if we have any press people here this morning. Either, and I like to single out our press friends when they're present in the audience if I know who they are, but I don't see them. And so we do have a quorum. We are on time. We're ready to go. And I had understood from a call yesterday from Ms. Haddon that Mr. Burnham, Representative Burnham, you have some remarks you want to make to us. Of course, we'll take those up first if you're ready, sir.
Chairman, I prefer to defer. I'm going to be able to be with you for at least an hour, and so let's play it by ear a little bit, okay?
All right.
I don't have a copy of the agenda, though.
Audrey, could you please get one from the back?
Got one now.
They're in the back, and we'll get one for you.
There weren't any back just now. They may have trying to save money or something. I got one now.
Very good. All right. That's items 1, 2, and 3 on our agenda. The next one is item 4, public comment. And anybody, this is a general query that we have on our agenda at the first each time for anybody who wants to address anything to us on any matter in particular if it's not on the agenda. But and anybody who does speak, of course, will have the opportunity to speak on an agenda item should they be asked, should they ask to do so and are recognized at the time that agenda comes up. But at this time, Ms. Haddon, I see you're here.
Good morning.
Good morning.
I'm Karen Haddon, and I'm here on behalf of the SEED Coalition, Sustainable Energy and Economic Development Coalition. And today we have some major areas of interest, and I know we've talked to you before. I'd like to just reiterate that on all the applications coming forward, we do have concerns about water at the site and the fact that it does not appear to be dry, and that poses risks of water contamination. We don't think that you should approve the applications coming forward. We're also concerned about the risk of explosions and potential radioactive releases because of the presence of the waste that came from the WIPP site and originally Los Alamos. We understand that's at the federal facility now. It's not a half-mile underground like it would be eventually at the WIPP site. And it does not appear, to my knowledge, that there's an adequate plan for dealing with an explosion if one occurred. So it doesn't make sense right now to be importing additional waste to the site until we can assure that there's not going to be an explosion, that workers won't be at risk, that the region won't be at risk for radioactive releases that could contaminate air, land, water, impact wildlife and all living things, including people. We are concerned about the overall site. That's one of the reasons, but also the fact that there's a hazardous waste facility there, and we'll talk more about that with agenda item 6, that there needs to be broad oversight of the whole site, and that the Compact Commission should be getting regular reports that involve the overall site. And lastly, the need for enhanced oversight in terms of rules and policies here. And thank you very much. Appreciate it.
Sure. Anybody have any questions of Ms. Haddon on the commission? All right. Robert, good morning.
Good morning. Robert Singleton. I'm a little concerned that no one is concerned enough about the waste from WIP that's stored on site, and for a very particular reason. And I'm going to admit that I'm getting into an area where I have very little expertise, and that's nuclear chemistry. But apparently I'm not alone, because the people at Lannel and the people at WIP were pretty confused about the chemistry that caused the reaction. As I understand it from reading press reports and a couple of technical reports, the thing that changed the chemistry in the barrel was the lining in a glove. Now, this concerns me not so much for the WIP stuff, although that concerns me, but even more it concerns me about the chemistry of reprocessing. If the chemistry can change sufficiently from the presence of one piece of metal in a glove to cause an exothermic reaction in a barrel to rupture and radiation to be released, isn't it possible that the same thing could happen with that incidental contamination from reprocessing? As I understand it, there's going to be a little bit of material from other reprocessing efforts that's still in the vat when the reprocessed material to be reprocessed is put into it. Isn't it possible we could have the same sort of unintended chemical response from an item that was not expected to be in contact with the material being reprocessed? Until we know the answers on that and on the barrel, I certainly would be very cautious about bringing any more waste in until they figure out what the problem is and how to prevent it. I understand from a press report this week that there may be a second barrel they think might have ruptured underground. And I think we need to find out why this is happening and make sure that it can't happen. And it's insufficient to say that the waste at the site is under video monitoring, because you can watch it happen, but what can you do about it? Right now, we ought to keep everything in place where it is. If LANL is a problem because of wildfires, cut fire breaks. It seems like standard firefighting practice, but just leave things where they are. And also, the recent rain in El Paso is concerning me in terms of water at the site. What would an unexpectedly wet winter mean to the water levels and the possibility of contamination at the site? And I just think the Commission needs to ask these questions, and also questions about transportation, because I understand that the liability for an accident en route to the site is still in some doubt as to how that works, whether it applies to the state of Texas, whether it applies to WCS, whether it applies to the person that shipped it, whether it applies to the person that generated it. But there are enough small transportation accidents, and luckily very few of these result in release of contamination. But they do show that transportation can be a problem. And then there was a truckload of radioactive waste in Ohio last year, for example, that was in a routine traffic accident that actually caused one of the casks to slide through the back of the trailer. So it was a pretty significant accident, and could have been significantly worse. And I think that's the kind of questions I would like to see the Commission get answered: transportation, water, and the safety of the material that's being stored, before you approve any more importation into the site. And this would include not just importation from Lannel and WIP, but also an analysis of how a problem with that WIP site material could affect operations and safety at the plant. Thank you.
Thank you, Mick. Go ahead, Judge.
What was that?
I'm sorry?
What was the wreck at?
It was coming from Fernald, the Fernald site, and I'll have to look it back up. I think I can find it for you in a couple of minutes and tell you.
When was it?
Last year sometime.
Yeah, but you just give me.
Okay.
Any other comments or questions from the commissioners? All right. Does anybody else wish to be heard under this agenda item number 4, commenting to us about anything of concern? Representative Burnham, welcome.
Thank you, Chairman. I guess I've already heard enough to speak my mind a little bit here this morning. I'm Lon Burnham. I'm from Fort Worth. I'm a state representative, and I've been monitoring the initial legislation from the early 90s passed setting up the compacts around the country. Since that time, and I was intimately involved with the legislative process here for the last 18 years, watching the evolving of this legislation. And I'm going to start out with my League of Women voter background and talk about the process. It is totally inappropriate that we did not get email notice about this meeting until within the last 48 hours. I didn't know about it until yesterday. I know it's posted on the website, but it would be so simple and so appropriate in the context of public participation that emails go out to the people that are on the requested list as soon as the meeting is set. It would be real easy for me to go back and look at the timeline to find out, oh, the room was reserved on what day? That kind of tells you, once you have your venue, you kind of know where you're going. It'd be real easy for me to go back, and presumably it's a matter of open record, the discussion of when we're going to meet next and where. I shouldn't have to do that. And no volunteer public citizen should have to do that. If we've requested the information, it is so cheap and so easy now for the commission just to make that communication to the public. The reason I asked my friend Karen Haddon to contact the chairman yesterday is I knew I was obligated through 8:30 last night. Unfortunately, I don't sleep very much a lot, and I was awake by 4 o'clock this morning, was able to get in here. It took me about an hour to do the Austin part of the trip, but as you well know, but I was able to join you on time this morning. But I feel like I'm a broken record because at virtually every one of these commission meetings that I speak at, I talk about basic respect for democracy and process, which this commission does not seem intent upon respecting. But I'm going to bring it up at every commission meeting I speak until we see an improved track record. I'm a slow learner sometimes, and it's finally occurred to me, based on various communications, that really the law's not very important in this country anymore, regardless of what the Compact Commission legislation says in the early 90s. The lead dog in this pack is Homeland Security, and they have suggested, requested, urged, admonished that we get everything we can to this site in West Texas from all over the country. And apparently they're intent on violating the law with regards to non-commercial waste. I don't know whether that's about Homeland Security or maximizing somebody's profits, but regardless, it violates the intent of the original legislation. So as is my standard, I will tell you I'm opposed to virtually all of your amendments today. I'm going to point out one in particular that is particularly concerning. But here's the issues. Time and time again, I come to these meetings and I ask for the information about water on the site. I'm dealing in public forums with people from the private sector that are perfectly willing to lie about the facts, but I can't get them from the commission. I want to know if water is still standing there. I think I have a right to know. I think the public has a right to know. I want to know how many gallons that we have pumped out of those sites because of the aquifers that are there versus the unusual rains that we have just had where there's flooding all over West Texas and eastern New Mexico because of the remnants of the hurricane. We have a right to know. You have a duty to know and share this information. So, you know, it's the water. It's the risk of explosions that we now see. Los Alamos clearly hasn't figured out the kitty litter chemistry of what should be involved there, and we can't get any information about it. And so, you know, as it's been my observation, 18 years in office, TCQ is really more about pandering to private interest than protecting the public health and public interest. So I don't expect that behavior to change anytime soon. But I wish this commission would divert from that trajectory and actively oppose item number 6. The mixing of the hazardous waste proposal is just simply insane. and you can't expect any outcome if you keep doing the same thing that you do over and over again, other than the insanity that that decision-making process represents. I'm just pleading with you because apparently I have no other recourse. Start enforcing the law. Start obeying the law. Start adhering to best practices when it comes to public participation by providing the information the public has the right to know. Not everybody wakes up at 4 o'clock in the morning thinking, oh, what have I got to get done today? I do. That's my mental health problem, not yours. But the fact of the matter is, I think we're on the wrong path. And I think it's because you are not challenging some attempts to make this the international waste up for God knows what all because of Homeland Security and maximizing somebody else's profits. Let's reevaluate our decision-making process here. Thank you, Mr. Chairman.
Thank you, Representative Burnham. Does anybody have any? Judge, go ahead.
John got lost. You said non-commercial waste.
Well, everything from Los Alamos is non-commercial. It's related to production of nuclear weapons, which we should have stopped doing a long time ago anyway. Which Texas certainly shouldn't become the repository for this nuclear waste fiasco. I mean, they screwed up at Los Alamos. They screwed up at Carlsbad. Texas is going to end up bearing the economic burden for their screw-ups because you guys won't say, wait, stop. No, that's not our responsibility. Thank you.
Anybody else? Dick?
Excuse me, I'll turn that off just a second. Yes.
Other than being more accountable and looking into these, within the compact law, what should we be doing? I mean, what are you talk about how this commission has got to look into the way things are being handled. It's got to stop waste coming in until it has, and that sort of thing. I mean, can you be a little more specific about that?
Well, if you go back and I'm neither a lawyer nor a scientist, but if you go back and look at the original legislation that is still in effect, adopted by Congress, that establishes the legal framework in this country for creating commissions, they were pretty clear. There were some reasons why they did that. Nothing officially or publicly has occurred to change that law other than possibly Homeland Security intervening in the process and suggesting that we should become the nation's national waste dump, which is clearly not the law, but it's not the only law Homeland Security has violated. That's where you go first. It's kind of like the Constitution. Where do you go to? What's your point of reference? The Constitution. The point of reference for this commission is to understand that national legislation, which this commission was established to enable the enactment of that legislation. And I just don't think we've done a very good job of that, whether it's because the Attorney General's office is not particularly interested in keeping people informed of the exact nature of the law, or there's some sort of potential conflict of interest. We simply have not done that. Further, it is a moving target, I understand, to understand what the state legislation involves, because every session since the initial legislation in 2003, special interests in the industry have changed the law. So I understand the difficulty in following that law, but there should be no difficulty in following the national legislation.
Okay, so the national legislation, I take it, is the whole body of legislation that regulates.
Well, there's a specific statute passed, and I can't recall the year right now, but it was the early 90s. That statute is the statute that established the framework for saying, okay, we've been creating nuclear waste since 1945 about. It's time to start figuring out how we're going to deal with this waste. And it's time to standardize, because it's in the national interest, have national standards. And so that's the reason they passed the compact legislation in the first place. And while we know that one of the three states in our compact has opted out, That's the reason we have a bilateral agreement with Vermont. There's 48 other states that are trying to put their junk, or 47 other states that are trying to put their junk here, and I have maintained consistently since day one, we have not done the financial assurance that we need, and ultimately it's fiscally irresponsible for the agencies involved with the state of Texas to not insist on adequate financial insurance and not accept the waste from, right now I think it's 38 other states, but it could be theoretically that we were operating as many as 47 or 8.
What do you think adequate financial insurance should be?
Once again, I'm not a financial analyst, but probably twice what's been offered up, and one should be particularly concerned that the assurance is completely tied to the corporate stability of WCS. It shouldn't be tied to their stability. In my own home community, the analogy that I use is, you know those apartments that look really nice when they're first built, but there's 200 or 300 in your neighborhood? Within 15 years, the investors have reaped all the profit that they need, want, or expect to get out of these apartments, and then they abandon them, not immediately, just kind of systematically over 3 to 5 years. I think that analogy is completely appropriate for the situation we're seeing here. We have no idea whether this company will actually exist in 15 years, and we have no idea whether or not we have the financial assurances in place to safeguard the state of Texas from their declaring bankruptcy and abandoning the site.
And you think that maybe doubling the
Once
security
again,
makes sense?
I'm not the.
We'll cover that.
Once again, I'm not the financial expert. I'm a good critic. I don't have a good plan in place because I don't have the professional expertise to offer you that plan.
On the business of notice of these meetings, I'm not a Texas lawyer, and I don't know the statutes so well down here on notice of meetings, but I think we've tried pretty hard to follow at least the notice provisions, and we do schedule our meetings. I mean, if anybody really cared, if somebody on your staff were here, or you were here at the end of a meeting, you would learn when the next 3 meetings is going to take place. You'd be into March, April, May.
That burden should not be on the general public. That burden should be on the commission. And I'll
What do
give
you
you.
want us to do other than what Texas statutes require?
Well, first, I'm not an attorney, and I know you're not from here, but I was here in 1973 when we passed the first public records legislation. I was an undergraduate and working here in the Capitol. There's a difference in making the intent of accessibility and meeting the minimum legal requirements. As I said earlier, I think it would be real easy to send out an email notice to all the interested parties that are listed saying when the next meeting is, as opposed to waiting till less than 48 hours to put it out. It takes almost no time or money to provide that kind of electronic notice anymore. I mean, that infrastructure is in place. And so while I may or may not be able to be at any one meeting the entire time, you're not the only state agency I'm trying to monitor and have responsibility for. The commission, the agencies have responsibility. Information cost, and it's the government's public sector job, whether it's public interest activist or the private sector. It's the government sector's responsibility to make that basic information as easy as possible, not to have to go search it on a website.
Is that what your legislative committees do? They send emails to everybody who might want to attend?
They would if I were chair. I'm not chair. I mean, it's a very easy task to accomplish. I have city council members that have sent out emails on special meetings for planning or zoning commission meetings. It's roughly the equivalent.
I just think there's a lot of notice that goes out from this. Anybody who pays any attention to this commission has ample opportunity to know when we meet.
This commission has adjourned without announcing the next meeting on any number of occasions. I can't cite you precisely which ones when. They're left pending. You may or may not be at the whole commission meeting. I was able to be at the entire meeting in Dallas whenever it was. Couldn't be at the meeting in Fairmont. It was kind of cost prohibitive for me. I'm just saying it is very, very easy to put out notice when the next meeting is electronically to the stakeholder list. And it's just not being done.
Dick, let me address this, because when Ms. Haddon called yesterday and talked to me about this, and I heard that Representative Burnham was going to talk about this, I had a conversation with Lee about it, and I'll be glad to talk about it, and so will Lee. And what I'm going to say, Representative Burnham, is that at the end, the last agenda item we have for every agenda that I can recall is scheduling of our next meetings. And we sometimes don't know the location. We know that they're in Austin, but we won't specify a room necessarily, but the dates are known. Secondly, we do have and maintain a listserv. What we don't have is a regular, and I learned this yesterday, schedule to know when we're going to distribute information about the upcoming meeting. We don't know whether it's going to be 3 days in advance or 5 days in advance or a week in advance. And the reason we don't, and Ms. Ing can speak to this if she cares to do that, and I'll let her talk about that. But the last thing I'm going to say is I appreciate very much Ms. Haddon texting me after she called me to complain about the short notice to let me know that, in fact, she had received notice by email of this meeting with the agenda that was distributed to her. It might have been only 48 hours in advance, or it might be 5 days in advance. I don't know when it was distributed. I don't get it. And so, it's on my calendar. So I know I'm supposed to be here. But Ms. Ing, why don't you go ahead and chime in?
We post after all the meetings, these commission meetings, usually within sometimes that day, sometimes the next day, over the weekend, because usually these are on a Thursday. We update the website, so all the meetings go on the website. We put that the meetings are tentatively scheduled, because until an agenda goes out, we don't want to. If something happens where you would want to change the date, you still have that opportunity. That's one of the reasons I don't send an email out after a meeting about when all the meetings have been planned, in case they could change, because y'all have that right to change them. Once the agenda is set and the meeting is now no longer tentative but is firm, there has been various opinions shared with me about when they would like that AWeber email notice to go out. Some people want it shortly before the meeting so they don't lose it in their email. Some people would like it sooner. Some people would maybe like it 4 or 5 days. And so we haven't put a policy together as a commission, if to the extent you even would want to set a policy about when that emailed notice would go out. The view of it has been that the email notice that we provide is in addition to the already statutory required Secretary of State notice that we do on time, as well as putting it on our website as we do. And so we haven't set a firm policy about when it goes out. We certainly could, or I could get informal direction, but there's a lot of opinions on that.
That lets you know that we did take the comments to heart, and we're trying to work out a strategy to comply with them that not only meets your expectations and Ms. Haddon's expectations, but the expectations of the others that we also deal with on a regular basis. And some of them, as Ms. Ing reports, don't want it that far in advance of the meeting. Others do. And so I guess we could do it both ways, and we could do it 3 or 4 times. We could send it out weekly
Mr.
or
Chairman,
bi-weekly.
my rule of thumb is if I want people there, I notify them as soon as it's happening.
Okay.
And then I give them a warning about a week out or so. And then I frequently do a day before. Now that's mainly people that I'm trying to fundraise from for one cause or another.
I understand.
And so maybe that third email would be redundant here, but it doesn't take any great mental activity to figure out once you have a date set. It would be nice to let people that have really busy schedules know. The people that make a living monitoring this commission, they're going to be here. They're paid umpty up dollars an hour to be here. But the volunteers, people like me, I'd kind of like to know, because my schedule is pretty much set by the first of the month for the next month, and I'll make sure my staff is more diligent about monitoring your website. But I think it's a real simple request. Once you know the date and the place, get the information out to the public with that stakeholder list.
Okay, we always post at least 10 days in advance.
You're
So
in
what your
compliance with
suggestion is-
you're in compliance with the law, and I appreciate you being in compliance with the law, because not all state agencies are. But I'm just saying it's real easy to go the next step.
All right, so what you want is not only for us to post, but the day we post, also send an email message to everybody on our listserv.
That would be
says-
great. Even TCEQ
Yeah.
sends out notices when they're posting things, because people just don't monitor the Texas Register on a daily
I'm
basis.
just trying to get to your requests.
I appreciate it.
Representative Burnham, and that's what you're actually asking us to do.
That's exactly
All right.
right, Chairman.
All right. Then, we'll take note of that, and I'm sure Ms. Ing is going to respond. Okay. The other thing I want to talk about generally is the low-level radioactive waste is what we're about. We're not about all radioactive waste. There is all sorts of radioactive waste that is outside the definition and scope of low-level radioactive waste. And so we're a low-level radioactive waste disposal compact commission. So that means that the transuranic material that's coming from Los Alamos National Laboratories to the site is not something that is low-level radioactive waste. And that's just not part of what we do. And that's, it could be that that's a deficiency in the system, but that is the way it works. As long as there is something defined as low-level radioactive waste, we have authority for that and nothing else. And so spent fuel is outside our jurisdiction. The transuranic stuff is outside our jurisdiction. And there are various things that are outside our jurisdiction, and that distinction that's set up in the federal classification system of waste is not something that is readily apparent to most people, and I'm learning that where I sit here.
Yes, it's not.
For those of us who deal with it, it's something that is apparent, but for people who aren't familiar with what goes on, that's part of it. And so there are things we can do, but things that are totally outside, I won't say the word totally, but that are outside our legal purview. And that has to do with the definition of low-level radioactive waste. So,
Mr. Chairman, I appreciate your revisiting that. I think you and I had that conversation at the last meeting. It may not have been in front of the general public. I completely understand you're making that distinction. I'm just saying that because the facility wouldn't exist if it weren't for the state legislation and the Compact Commission. The Compact Commission has a vested interest in monitoring what kind of crap we accept from out of state, from the military-industrial complex.
and I can't help but observe, Representative Burnham, that the legislature said that the state of Texas is responsible for the entire complex. And as a matter of fact, the part of it that Texas owns is the Compact Commissions. We pay really close attention to that. But the state of Texas doesn't own the rest of it up there. Ultimately, the Department of Energy is going to own the federal facility, but that's after it's closed.
Right, but the state of Texas does have regulatory responsibility. That would be the TCEQ. And,
Thank you for saying that.
And we know the track record there.
Okay. All right.
Thank you, Mr. Chairman.
Sure.
It's always a pleasure.
Yes, sir. All right. Is there any other person who wants to speak in terms of agenda item number 4 who wants to address matters at the Commission? Seeing no volunteers and hearing nobody else stand up and say, I do, we'll close that item. And next, we'll take up item 5. In item 5, and I'm just going to make this announcement. Item 5 is a discussion of possible potential action on revisions to 2021, 22, 23 of 675, which are mainly our current rules. Section 675.20 would be a new one. But I'm going to also discuss, at the same time, I'm going to consolidate this item with discussion and potential actions associated with the record exemption subcommittee. And I want these two, and it'll become clear why I want them merged, but we're going to talk about both of these agenda items at once. And at this point, and this is pertaining particularly to item 5, our agenda item 5, I'm going to turn it over to Ms. Morris, who has been very ably and very wonderfully, from my point of view, acting to help us with the rulemaking, looking at the existing rules and revising them. Linda?
Okay, thank you. Thank you to everyone who sent in comments regarding 675.20 through .23. The members of the committee, the Rules Committee, did meet last Friday here in Austin, and we actually sat down and looked at comment by each and every comment. So we spent a lot of time doing this. We did see some things we obviously need to change, and we'll do that. Other things bear further discussion. Bottom line is that we are going to, we need to make some more changes. So what we're going to do, we're going to ask Ms. Watkins, our counsel, to continue to work on making these changes as we've been discussing. We're probably going to wait on .24 to come about, and that'll be discussed further in just a few moments, so that all portions of 675 can move forward together. I'd really like to see that these rules are in pretty good shape by the end of this year. Our next meeting, of course, is November 13th, and after that, it's December 17th. For everyone's information about when the meetings are. So we are going to try to get something. There's a lot of deadlines and stuff that have to be taken care of between now and then, but I'm pretty sure that we're going to be able to get stuff together for all these .20, .21, .22, and .23 and .24, and get something proposed to the Commission before the end of the year. So we're looking at approximately December 17th. We'll hopefully even have something available to further discuss at the November meeting on November 13th. So that's kind of where we are right now. And again, we appreciate all the comments that were sent in at the last minute in many cases. But still, there were some very good comments, and we do appreciate all the good suggestions that were made. So we're certainly taking them seriously and considering each and every comment that's made. So, and we'll still be accepting comments, because remember, these are working draft rules at present. They have not been published in the Texas Register. So this is something that we're all working on together right now, you folks as well as the Commission and the Rules Committee. So we'll still appreciate your input. And anyway, so I'll turn it back over to Chairman Wilson.
All right. Thank you, Ms. Morris, both for your work and for the report. And the next thing I'm going to do is call upon Mr. Hurley, and this will be under item 6 to tell us about where the record exemption subcommittee is.
Our subcommittee met while we were in Vermont and had some initial discussions that really led to the conclusion that we needed to do more investigation and talk to some of people that would both be impacted and would have information that would be relevant to our discussion about the idea of the treatment of exempt waste that goes into the RCRA facility. We have started that process. One of the conclusions was that obviously what we are going to do has a dovetailing impact with what the Rules Committee was going to do. So one of the things we had discussed was that this is the concept of what would be .24 in the rules to address this issue, and therefore what we had asked was that we start to consider and think about what .24 should be. There's not a draft of that currently, and we are still in the process of doing more investigation, but I believe what the chairman is going to announce is that we are now going to try to synthesize the two committees in an effort to try to address what should be .24.
Thank you, Mr. Hurley. And that leads me to say what I'm going to do in the light of these reports. And obviously I knew about them before. One, I have been serving on the Rules Committee. not the subcommittee dealing with RCRA, but on the Rules Committee. So I was involved in the meeting that took place last Friday afternoon. And at that meeting, it became clear, based upon some comments that were received to the draft, that there is an inclusion of some language in the draft about waste arriving under a manifest, a particular type of waste manifest that comes in as low-level radioactive waste to the state of Texas, and how to treat that. And the answer to that would be that we needed input to look at where that waste goes, and that was the RCRA subcommittee. So it became apparent to me during that meeting that the efforts of two committees to address this was probably going to make the process longer and be more complicated than it would be if we consolidated the committees. So having done that, and checking with our council to make sure that this was okay today to do, what I'm going to do today and right now is to consolidate the two committees. And for everybody's review, their Rules Committee was myself, Ms. Morris, Mr. Saudick, and John Salzman has been helping us a whole bunch. And so my problem was I needed to constitute a committee that didn't have a quorum of the Compact Commission members in it. The RCRA subcommittee, Mr. Saudick again was participating. Mr. Salzman was officially named. Mr. Hurley was the chairman of that committee. Judge Dolgener was also operating under that committee. So I made the decision to reconstitute both of those committees and form one committee, and we could call it Rules 2, or we don't have a designation for it, but the new committee that's going to be carrying through with this effort is going to be composed of Ms. Morris is going to chair the committee. Its members are going to be Mr. Hurley, Mr. Salzman, and Dick Saudick. So the judge and I will no longer be involved in this process. Those are the four people who will be serving both to finish the ideas, responding to comments that have already been made, updating the draft rules that have been on our website for some time, associated with the changes that we had originally been concluding, and we hope incorporating the ideas of the members of the RCRA subcommittee, I'll call it, so that now there is a uniform set of rules that will be coming out. In talking to Ms. Morris about this, when I told her I was going to make her chairman of this committee, I can't say that she volunteered. But as you heard, what she's planning on is seeing if a consolidated draft, at least with some ideas, can be available for discussion in November. But we'll talk about it. As soon as we have something, we of course will put it on our website. We are really looking towards a December date to have a version that the entire commission will consider and act on at that time. First off, are there questions from any of the commissioners? I think almost everybody has had a bite of this, except maybe Peter.
It's all right, I'm in no hurry.
And but it seems to me that the process would be faster, quicker, smoother if we do that. And so I have to say that the issue of importation of waste into the state that goes to the RCRA facility is not something that, in my mind, I'm not sure about Mr. Hurley. He's been looking at this a lot closer with fresher eyes than mine. It's more complex than it appears on the surface. And so that's the reason that they were in the process of continuing to gather information. I do get reports from them, even though I'm not participating. And I just got a vague report through our Common Counsel, Ms. Watkins, And then, so I think it'll work better with one committee. And that's really items, what I'm proposing on is item 5 and 6. And I think I have the authority to just do it. And that's what we're going to do. So that'll be the action today under 5 and 6 unless somebody objects.
So moved.
I don't need a motion, but I gather that's the direction we're going to go. Any other comments? John? All right. That takes care of 5 and 6. A question, Ms. Haddon.
Just a comment. I'm hoping that Chairman Morris will let us know when the committee will meet. We have made a point in the past of trying to be at subcommittee meetings, committee meetings, and I think it should be open to the public. And also, we may still have some comments coming that have to do with the rec recite, especially since that's not written up yet. Thank you.
And
Excuse me, may I just ask?
sure, Dick.
Is there you said it should be open to the public. Is there a requirement that it be? I just don't know.
I have always thought that it was in fact a requirement under state open meetings laws. I know that this was debated at one point in time. My interpretation, my own personal interpretation, and I'm not a lawyer, is that yes, they should be.
And the process, Ms. Haddon, there is a separate process of the committee meeting to work up a draft. And I think the intent is, and I haven't specifically talked to Ms. Morris about this, at some point along the way we will have, in effect, a stakeholders meeting to talk about it, where everybody will come in. And because the other people who are involved clearly are WCS and to some extent TCQ and Department of State Health Services and even other operators and processors and generators. Now, the committee has difficulty drafting in a forum like that. They certainly can receive comments, but it's difficult for them to do their work. So I anticipate that the committee may have meetings of just the committee members working on specific language in context, but I think it's also the intent that we do involve stakeholders in the process at some point.
Well, I think that that's more acceptable if there's some assurance that it is in fact just committee members and not any of the other parties involved.
Ms. Haddon, I will note that you know my telephone numbers. And I'm sure that you know the telephone numbers of the other people who are on this committee, and it's up to them to decide who they want to talk to, but we're pretty open about talking to anybody who wants to talk to us about these things.
Right. My concern lies out of historical perspective, and I know it was a long time ago and you were not the chair at that time, but there were committee meetings held at which the public was excluded, and yet WCS and others were part of them. We watched the group move out to go meet, and that's unacceptable. That does not meet the scrutiny of public meetings. Thanks.
Linda.
All the Rules Committee meetings we've had have just been the commission, their staff, and the council.
Okay, great, and I look forward to the ones that involve stakeholders. Thanks.
All right. Robert?
Oh boy, this takes me back. I've fought with the Austin City Council a number of times over the Open Meetings Act, and my impression of the law is this, and again, I am not a lawyer either, that meetings are assumed to be open unless they're closed, and if they're closed, you have to meet an open session, announce the section of the Open Meetings Act that the exemption applies under, give the public an opportunity to comment on the reasons for going into closed session. Now, I know this is a problem because the mayor of Austin eventually got sued over this issue and lost. He was taking council into executive session without providing an opportunity for the public to object to the reasons for going in. So the precedent that I've seen under the Open Meetings Act is that if you're going to go into a closed meeting, you have to first go into an open meeting and announce why you're going closed.
our lawyers can speak to this, but as somebody who represents political subdivisions, I can tell you this: if the commission were doing that,
Yeah.
you're correct. But the commission is not doing this. It's a committee of.
It's always been my impression, reading the Open Meetings Act, that the open meetings posting requirements and other requirements also apply to subcommittees. And that's always the way it's been in my experience with city government, at least.
Very well. I'm glad you have that opinion.
Okay.
Go ahead.
Thank you, Mr. Chairman. My name is Tom Majette, and I'm here representing Energy Solutions. And we appreciate the new committee that you've formed and putting the two together. And we recognize that it's going to take some time for that committee to complete its work regarding the rules. And I would just like to remind the Commission that Energy Solutions submitted a letter a couple of days ago requesting that, in lieu of the fact that that will take some period of time, that the Commission should act to prohibit the disposal of low-level radioactive waste in the exempt cell until such time as the rules are completed. The rationale for that is articulated in the letter. It was over the signature of Mr. Dan Schrum, and I just would like the Commission to consider taking that action at its November meeting.
Mr. Majette, I'll say that, yes, we got your letter. It was sent in to the Commission's office. It's not on the agenda today to act, and the only thing we can do today is doing what we're doing. It certainly is something that I'm sure that we will talk about as we develop the agenda. The implications of it are interesting to us, as I'm sure that they are to you and to WCS and the other generators who might have agreements in place. And it's something we want to deliberate pretty seriously.
Understood. And Energy Solutions wasn't suggesting that you should take the matter up today.
Okay.
Thank you.
Thank you. Mr. Balzer.
Rod Balzer, President of WCS. With the exempt discussion, I thought maybe it'd be beneficial if I sat here and tried to explain a little bit our rationale and clarify any questions you may have on this exempt process. I don't think it's as complicated as people are trying to make it out to be. The Nuclear Regulatory Commission has a process to exempt things. It's 20.2002. Texas has taken that and adopted that program for WCS. And we are exempting things in our treatment and processing facility. Once they're exempted out, then they can be disposed of in our hazardous waste landfill. That stuff all arrives as low-level waste. It's treated that as it goes through DOT and everything else. It's as it's low-level waste. And then when it arrives to our facility, we sample that to make sure it meets all the criteria and then dispose of it in our hazardous waste landfill. That process was approved by TCEQ. There was a public comment period before that amendment was passed. None of the people here today who are raising this as comments to the Texas Compact Commission raised that to TCEQ. There were no comments on that. So I'm somewhat surprised why they'd come to this agency when that is a program that is resided over and has all the criteria at TCEQ. But I did want to clarify, it sounds like Energy Solutions is trying to put some kind of gag order or stop order on the exempt process. Obviously, they're trying to create uncertainty so that our customers will be unclear and try not to use that process. And I just want to make sure that there is some clarity for our customers and future contracts, that I understand the Commission wants to look at this as part of the rules and determine whether there's a role here and what that is. In our comments, we responded that in, I think it was 6.02 of the compact, basically says that the Commission shall not prevent the importation for alternative disposal, which would basically be exempt. So we believe there is not authorization, but we recognize you still want to debate this and go through the rules process and things, and I'm sure we'll have some discussions. But meanwhile, I just want to make sure that we are, I'll say, business as usual, and there isn't a perceived attempt to stop this process at this point.
Mr. Balter, thank you. And I'm just going to observe, and this is just that the only thing we pay attention to is what the compact says. And we understand that TCEQ does what it does under the authority that it has, just like other agencies do what they do under the authority that they have. The provision that you cited under the compact law refers to a different provision in the law, and basically it's a prohibition against, and I could read it specifically. Sir? 6.02, no person shall manage or dispose of any low-level radioactive waste within the party states unless the low-level radioactive waste was generated within the party states, except as provided in 3.056. If you go to 3.056, it says, if I can find it quickly, enter into an agreement with, this is in the Compact Commission, we can enter into an agreement with any person, state, regional body, or group, or states for the importation of low-level radioactive waste into the Compact for management or disposal, provided that the agreement receives a majority vote of the Commission. And those two provisions are what we are concerned with. We don't, TCQ can do what TCQ does. We don't have any problem with that. What we have a problem with are these two provisions in our compact. And that's what we're looking at, okay?
Yep.
Anybody else?
Yeah, when you raised that, I just was curious about what legal authority you felt. You feel 6.05 in effect deals us out from that?
Yeah, on the, we think on the 6.02, when it talks about alternative disposal, there was an NRC regulation that's been replaced by 20.2002, but that clearly implies that the Compact Commission would not be able to prevent the importation, I'll say, of that kind of waste for disposal, for alternative disposal. So if, for example, our exempt process applies to federal generators as well. So if DOE is sending waste in through this process, it's being exempted, it's going into the same RCRA landfill, it's using the same exact process. If it was not exempted, it would still not have to get import because it would be going to the federal facility. And so it is outside the scope of the Texas Compact Commission. For commercial generators, if it was not exempted, then it would have to go to the compact facility and obviously would fall within the jurisdiction of the compact facility.
And that's the last sentence of 6.02, and it says, nothing herein shall be construed to prohibit the storage or management of low-level radioactive waste by a generator, nor its disposal pursuant to 10 CFR Part, the reference is 20.302. And so one of the things that the RCRA subcommittee is doing is looking at that series of regulatory requirements, what used to be 2302, to see how it now works.
Yeah. And we would love to participate and address any questions that subcommittee may have. Obviously, this is a topic near and dear to our hearts.
I am sure you'll have that opportunity at an appropriate time, as others will also. Okay. Anything else? Thank you, Rod, as usual, for your comments. Yes, sir. Mr. Majette.
Thank you once again, Mr. Chairman. I would just like to address one of the comments that Mr. Balzer made, which is as to why these issues are just coming up now before the Commission. Really, the answer is twofold. First of all, the TCEQ rules regarding standing are very strict and limited, and Energy Solutions simply isn't granted standing before that organization in order to make those comments. That's why they weren't raised then. Second of all, clearly this is within the jurisdiction of the Commission. It's been established by the federal courts. The Low-Level Waste Policy Act of 80 and the Amendments Act of 85 and 86, particularly 86, that made those compact agreements part of federal law, establishes that if it comes into the state or into the compact region on 542, manifested as low-level radioactive waste, it is indisputably and undoubtedly under the purview of the Commission. If it comes in as exempt, that's another matter. But if it's coming in as low-level waste, it's clearly within your purview. That's why Energy Solutions brought this matter to your meeting today.
Thank you, Mr. Majette. Robert.
And I realize this has no legal importance, but one of the reasons we talk to you instead of talking to TCEQ sometimes is you're easier to talk to. When we went to the TCEQ to talk about this issue, they didn't take any public comment. They voted on some major changes for the site, including the trebling of the size of the site without any public input.
Thank you. And again, we're not TCEQ. So, any commissioners, any more comments from the commission? Well, I don't think it needed a motion, but we're ready to go, and I think we've established the new committee, and they'll begin their work, and Ms. Morris will be chairing that committee, and the members, as I said, will include John Salzman, Mr. Hurley, and Mr. Sadek, and that's who's going to be parsing through all this for us. We'll see how it goes. Well, I'm sure the debate will be interesting and lively, and we know we'll have two very active participants in the entire debate process. Thank you. Okay, that's items 6 and 7. We've been going for an hour. Why don't we get up and take a little short break for about 15 minutes and give us a chance to shift gears to doing the business of the Compact Commission. So we'll be back at about 11:15.
Yeah, that, which part of that can be problematic, but when I read that, I thought, okay, well, here's a way, this piece of legislation, sources, they could, based on the same law, legislate that all these new sources be disposed of. Right. Within your experience. Right. If they adopted some legislation, yeah, go ahead. And then of course, thereafter, a 2-year, yeah, then you have to dispose of it 2 years. Yeah. So, what I'm stuck with is how do I get this comment forward? Yes. Yes. Consideration. Interest as well. Yes. Because my organization, we can comment on certain words. I talked to Todd Loving. So he didn't feel like it's So I'm trying to figure out how to get the organizational agreement is being comments for, but their comments are that they shouldn't be doing this.
Yes, I know.
Yeah, they should just like and I knew that if board would they would share other states.
So I'll be honest with you. Why? How it is that the medical facility security legislation is which part of whereas it's not. I don't know. One of the odd things is that the reports. The medical security standards. It's never been pushed to make things regulatory in that report. And then they pop out here. Whereas we have pushed very hard for first in 2010 and now to get the financial assurances and the other sort of the use plan as recommendations in the report. And I and really just pull back. Robert, so I am married to Smitty. Okay, you're married to Smitty. But maybe
so are we together? Yeah, I thought you were married together.
And of course, the challenges that sort of, I just don't deal with it. And so, but I will let questions. That's right. I have no idea. It may be a state or regular such as yourself, sort of running area in that like an entryway for a federal agency and Congress. Congress that has to have some reason or other. Well, I don't know.
I know during the OAS meeting last week, Laura Dukes, she did to the Hill.
Yeah. Who said this?
Laura Dukes. She's the director.
I know the name, but
she's the director of the group that's over all this.
Okay, understood.
And so she was up there, basically, probably trying to get
yeah. So she was up on the hill.
Yeah. So she must have been invited and she encouraged all the states. And of course she's trying to squash it. But this is for sure. I'm for the idea of what's I think the execution is
The execution of which in particular?
In the rules. Well, some of them like the 5-year time frame, especially since things from the NRC have essentially
Sure.
It doesn't also all of the NRC agreements say security training. I think they don't need all the training. It just needs to go through the process to certain elements of it. I mean, just things like that. There's easier ways to do it. And if someone who is new to inside out of the actual process and currently stands could drive this.
Yeah, you're absolutely right.
But as you said, I think that given that NRC's put in road traffic companies, legislation may be that's why
you know, it's one of those things where I don't think this is the first time it's sort of gone through very many sort of iterations. But it takes
And this is a discussion. It's not the actual vote itself, but it's kind of a discussion, talks about the history of this and how the NRC came about. So decided that we're going to give an exemption. So essentially, this rule, what you're pushing to is an exemption. And they said, you can't say why it should be done. Substitute reasons why it should be done.
It's clear
That there's a way out to do anything, essentially.
But yeah, I think that's good.
So reinvent kind of.
I also
really
put
talk
together
about
some
things
comments
about why they came up with this.
Yes.
It's not, it's actually NRC.gov
There are a couple places
website,
where
but this is the, it's actually,
their reports are short. Miss Allen, like this evaluating tables, something that's not good, but we're finding it so important. So,
glasses on here, so I can't see anything. Usually you can push these things over. Yeah, and that gives you kind of history. Yeah, it's hard to find. But anyway, so essentially, and then, so
She does a lot of
well, you
guys keep up the good work.
federal stuff. So they have,
but those comments aren't there. This legislation, if we're gonna be here.
Whether you, there's, they're using this similar.
So do you know if NSA is working on?
I don't, and just because of my role, I tend not to be. I change every place.
Like, wait a second, okay.
Oh, hi Karen, it's good to see you.
Hi, pleasure. Yeah, well, I was just fine.
Oh, I've been crazy busy. There's so many things going on.
You know, we're all volunteers.
Yeah.
So time.
Yeah, this is just one.
I'll find out for you. That's the best I can do. Isn't that funny though? Because it doesn't even occur to me to work that angle. I am just very federal interactions focused in terms of my own stuff on all states.
What I can do is send comments.
Yeah.
And they're just drafts. There's some ideas. If there were a way to tweak the legislation.
Absolutely. Absolutely.
Because, I mean, if we could get some sort of law in place to regulate time disposal, that sets the rules. Satisfies what DPR is trying to so,
All it talks about is that
but like I
they're
said,
giving away out. So the Texas compact, they put this license.
okay, what's up?
So it doesn't specifically say to do it. It's just specific.
Not the
So I didn't get to say hello.
I mean, anything that's been exempted by the NRC as distributed as exempt.
Starting down where you are. We're also good with that.
Yeah, I don't think that's changed at all. And as far as TSHS goes, TCQ exempts it, just like Texas. For our licenses, the only thing we need to know, because it's being disposed of in a non-licensed site, they just need to tell us. Say it's okay. So, I'm trying to get it.
I know, it's not easy at all.
And probably tweak it. And it didn't like the way, even though I wrote it, I wasn't happy with the language. I couldn't figure out a better way to word it.
You never know. When you, well, when you're doing that stuff, you're so like, it's this close, that it's hard to like take a step back until you separate it.
Well, and it's so difficult to make something so it's technically and legally precise and understand it at the same time.
Absolutely.
It's so,
That's why I have a job.
it's so difficult.
That's the entire reason I have a job, is to translate, you know?
Yeah.
I understand. Translate to the generator.
Go back over to the city side when you got 10 people working.
Yeah, no, I think they are now.
I went to a fundraiser for one of our candidates in my neighborhood down in Onion Creek. You know, we really wanted to be a student. But it's kind of funny. Like you, I don't know what their rates are. Early 80s and the more changed, the more these things.
You have to count a pretty hefty amount of biomass. Yeah, there's a question of well, yeah, it's in the energy. It's kind of near what it is. Yeah, it's not
buddies,
down by
you'd be very surprised about this. One of my best buddies is Kentucky. And he and I have a lot of fun talking about that. Of course, this is his secret. I mean, he wanted to do this. That's so funny. And they, yes, now what's next? Oh, public I like that. I can see your hand in it. The next time I was together, my district went all the way to Town Lake. Your drill goes 10 miles.
Okay, folks, our normal 15 minutes has stretched into our normal 20, but if everybody will gather up, we'll try to get started again.
Actually, it was you that was in the chair. When I was talking to you, they kept saying, it's thought it. Thought it. Thought it. All right, so I'm John.
No, that's just tell you. I went to one. Are you in fact?
It's all technical.
I went to a meeting last night for Rodriguez.
All right. I think the next item is item 7 on the agenda, and this is Mr. Salzman's purview, of course. Consideration of and possible action on each of the following requests for amendments to agreements. And the first is 7A, Radiac Environmental Services. Mr. Salzman.
Mr. Chairman, the technical committee received an amendment request that was 1-0059-01. In this case from Radiac Research Corporation. requesting that, pardon me, that New Jersey and Connecticut be added to the list of states authorized to send waste to the facility. And they also requested that the expiration date be extended from March 12, 2015 to August 31, 2015. I would note that date change would put the expiration of the agreement to the end of the operating year. There were no changes requested to the volume, the curies, radioisotopes, waste form, waste classification, kinds of waste, or anything else. So the committee has reviewed this, and we recommend approval of the amendment, and I'd be happy to answer any questions.
Any questions of Mr. Salzman on his report from the commission?
Mr. Chairman, may I just ask, this is the first I've seen of this, and when they say add New Jersey and Connecticut to the states listed in Article 2, Item JC, agreement, I take it they're talking about the compact agreement? No, because JC isn't in the compact.
I think item JC is in the
Importation agreement.
The importation agreement that is signed by the chairman, the actual agreement with the
okay,
entity.
I see.
I think that's the provision number.
Okay. I think Vermont would have concerns if both New Jersey and Connecticut wanted to sign up for the compact.
You don't think the state of Texas wants the $30 million or whatever it is from each one of them right now?
That's my concern.
And probably legitimate.
All right. Any other questions or comments from the commissioner? Okay, John, I'm ready for a motion.
I make a motion that we approve the amendment request, which was numbered 1-0059-01 from Radiac Research Corporation, to add to the list of authorized states from which waste can be received, add New Jersey and Connecticut, and to change the expiration date of the agreement to August 31, 2015.
Is there a second?
Second.
Okay, a motion's been made and seconded. First, are there any questions from the commissioners that haven't been asked or need to be answered? And Robert, do you want to talk to us about this?
Yeah.
Okay.
Couple things. First, I'm glad that you're not going to include New Jersey in the commission. That would be one meeting where you probably would change the politics of everything concerned if you had to have one meeting a year in New Jersey. I just have a question about the agenda as it was posted on the website. This doesn't appear to be the same copy that was on the website when I looked at it 2 days ago. For example, RAM Services Incorporated is no longer on the agenda. Does this represent an item that was pulled from the agenda?
It's for next month.
Oh, all right. Okay. Well, I'll see you next month then.
You can make comments.
No, that's fine. I just wanted to know, apparently I was looking at the wrong agenda.
All right. We did post, I think they've already been posted, requests for agreements that have already been received for comments. Those have already been posted. And so I think maybe there was some confusion there about agenda items versus requests. Okay. Any other comments or questions? Okay, then we have a motion and a second in favor of granting the request of Radiac Environmental Services. You mentioned, John, is it Radiac Environmental or Radiac Research?
The official, the form they provided, the official name is Radiac Research Corporation.
Okay, and we have it listed as Radiac Environmental Services, which we take are the same people. Okay. All right. I guess I could say, how do I want to describe Mr. Jacoby? But Mr. Jacoby provided assent that they are the same operator as a consultant. That's a good way to put it. All right. We have a motion made and seconded, and all those in favor of the motion, please signify by saying aye.
Aye.
Any noes? Any opposed? Any abstentions? Okay. Being 1, 2, 3, 4, 5, 6 ayes, chair not voting, motion is approved. The next is 7B, Tennessee Valley Authority, requesting an amendment to an existing agreement. Mr. Salzman.
The technical committee has received and reviewed an amendment request is 1-0031-04 from Tennessee Valley Authority, and TVA is requesting that the expiration date for their agreement be extended from September 31, 2014 to November 30, 2014. And they've indicated in their amendment request that it was due to some shipping cask constraints that they are under. They are not requesting any changes to the volume, the curies, individual radioisotopes, waste form, or waste classification. And the technical committee recommends approval of this amendment request, and I'm happy to answer any questions.
Okay, any questions, Mr. Salzman? No questions, John?
I make a motion that we approve the amendment request number 1-0031-04 from Tennessee Valley Authority, and that we change the expiration date of the agreement to November 30, 2014.
Is there a second?
Second.
Okay, motion been made and seconded. Is there any discussion among the commissioners? Questions? Anybody in attendance want to comment about this particular request? Signal volunteers. I'll call for a vote. All those in favor of the motion to amend the agreement as requested by the Tennessee Valley Authority, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes. Same vote is on Radiac Environmental. The next one is 7C, Xcel Energy Monticello. Mr. Salzman.
The technical committee has received and reviewed an import amendment request number 1-0045-01 from Xcel Energy Monticello. And in that request, they have asked that the total radioactivity be increased from 137 curies to 250 curies. So that would be an increase of 113 curies. And that the expiration date be extended from August 31, 2014 to December 31, 2014. They have not requested any changes to the overall volume or individual radioisotopes, waste form, or waste classification for the materials. I sort of have a question, and that is, I don't know that this has happened before. Their original agreement has already expired. It expired August 31, 2014. So is it appropriate for us to change an expiration date for something that's already expired?
This was a discussion that Jim Krausen and I had actually at the meeting in Vermont as to the appropriateness of a request coming in prior to expiration, but we don't meet until after expiration, as is the case with this one, as they do in other authorization processes at other agencies in the state of Texas. You can sort of, when the commission doesn't meet, or if you submit a change before expiration, it can be considered timely. And so that was the issue that happened with Xcel, that we put it on this agenda even though it expired August 31st because we hadn't met, but they got it in time. That could be something that y'all could consider as part of this decision.
Thank you.
I just observed that may be something that our Rules Committee should take into account when they're drafting our rules, when we deal with this kind of thing, to see what happens, because we could clarify that in our rules too.
The technical committee recommends approval of this amendment request.
All right. Any other questions? Other than Mr. Salzman's question we've addressed? Okay, John, I'm ready for a motion.
All right. I make a motion that we approve the amendment request 1-0045-01 from Excel Energy Monticello, and that we increase the total radioactivity to 250 curies, and that we change the expiration date to December 31, 2014.
Okay, is there a second?
Second.
Your motion been made and seconded to approve the amendment request. And as stated in the motion, is there any other discussion among commissioners? Questions? Anybody in the audience care to comment or question? Okay, nobody comes up. So therefore, I'll call for a vote on the motion, item 7C of Excel Energy Monticello to approve the motion. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion is approved. 6 ayes, no opposed, chair not voting. All right, those are 7A, B, and C. The next agenda item is item 8, consideration possible action on the following applications, proposed agreements for importation. 8A, Bionomics. Mr. Saltzman.
Mr. Chairman, the technical committee has received and reviewed an import application number 1-0074-00 from Bionomics Incorporated. That application was signed July 27, 2014, and received by the Commission officially August 1, 2014. In this application, Bionomics is a broker who is a licensed waste collector, and they're requesting authorization to dispose of non-party low-level waste in accordance with the Act. They are requesting authorization to dispose of Class A, Class B, and Class C stable sealed sources encapsulated in concrete. And I would note that material was authorized for disposal in the compact waste facility by TCEQ in a letter dated December 2nd, 2014. Bionomics is requesting a volume of 75 cubic feet with a total radioactivity limit of 125 curies, including 200 millicuries of C14, 10,000 microcuries of technetium-99, 1 million nanocuries of I-129, and 10,000 microcuries of depleted uranium. I would note that the applicant, actually the language in their application indicated they wanted to receive material from all states and Puerto Rico and the District of Columbia, minus the Northwest Compact and the Rocky Mountain Compact. So it's a very long list of states. I'm not going to read the entire list at this point, but I will read it for my motion. Needless to say, I think that equates to, if I did the math right, it's something like 37 states plus Puerto Rico and D.C. They will need to provide export authorizations from any waste that comes from the Southwest Compact and or the Central Compact. And to date, that material has not been provided, but would need to be provided to the Commission prior to disposal or any disposals. I would also note that the applicant has requested that the material would be considered under a small quantity generator set aside, and based on the volume and curies that they've requested, I believe that request should be granted. And I'm not aware that the applicant has access to another disposal facility for the materials. And the technical committee recommends approval, and I'd be happy to answer any questions.
Any questions of Mr. Salzman from members of the commission? Hearing no questions, John, I guess I'm ready for a motion. And your long list of states and territories.
Just 1 second. I make a motion that we approve the import agreement number 1-0074-00 from Bionomics Incorporated. The date of signature was July 27, 2014, and the date of receipt by the Commission was August 1, 2014. The expiration date would be August 31, 2015. The states are Alabama, Massachusetts, South Dakota, Michigan, New York, Tennessee, Arizona, Illinois, Minnesota, North Carolina, Arkansas, Indiana, Mississippi, North Dakota, California, Iowa, Missouri, Ohio, Kansas, Oklahoma, Virginia, Connecticut, Kentucky, Nebraska, Delaware, Louisiana, Pennsylvania, West Virginia, Florida, Maine, New Hampshire, Rhode Island, Wisconsin, Georgia, Maryland, New Jersey, South Carolina, and Puerto Rico in the District of Columbia. The waste description is sealed sources encapsulated in concrete. The waste classification is Class A, Class B, and Class C. The waste form is stable. Total radioactivity, or excuse me, the volume is 75 cubic feet. The total radioactivity is 125 curies. C14 is 200 millicuries. Technetium-99 is 10,000 microcuries. I-129 is 1 million nanocuries, and uranium-238 is 10,000 microcuries. And the agreement should include a provision that the Bionomics will supply to the Commission any export authorizations from material for the Southwest Compact and the Central Compact, and generator authorizations in no more than 5 total submittals of information.
That's your motion?
That's my motion.
Is there a second to the motion?
Second.
Motion's been made and seconded. Is there any discussion among the commission members? Questions? Does anybody in the audience care to comment about this particular item? Okay.
Yes.
All right. Motion been made and seconded to grant the application of Bionomics as stated in the motion. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Okay, big 6 ayes, chairman not voting, motion passes. Next, 8B, Duke Energy Brunswick. Mr. Salzman.
Pardon me just one moment, Mr. Chairman.
Sure.
The technical committee has received and reviewed an import application number 1-0075-00 from Duke Energy Brunswick Nuclear Plant. That application was signed July 31, 2014, received by the Commission August 1, 2014. In this application, Duke Brunswick is a generator requesting authorization to dispose of non-party low-level waste in accordance with the Act. I would note that the material Duke is proposing to send would be Class B and Class C stable and unstable powdered resin filters and irradiated hardware, and that the TCEQ has approved those materials for disposal in a letter to the compact waste facility operator that was dated September 2, 2014. Duke Energy Brunswick is requesting 725 cubic feet, 61,200 curies, including 6,000 millicuries of C14, 80,000 microcuries of technetium-99, and 1.2 times 10 to the 10th nanocuries of I-129. The material will be coming from the state of North Carolina, which is unaffiliated, so no export authorization would be required. They have, the applicant has no unresolved issues with the Commission, nor with any other regulatory agencies that we're aware of. I would also note that they have requested authorization to dispose of waste from September 1, 2014 through August 31, 2015, so for the third operational year. And the technical committee recommends approval. I'm happy to answer any questions.
Any questions of Mr. Salzman, of any of the commissioners? Okay. I'm ready for a motion then, John.
All right. I make a motion that we approve import agreement request 1-0075-00 from Duke Energy, Brunswick Nuclear Plant. The application was signed July 31, 2014 and received August 1, 2014. This state where the materials will come from is North Carolina. The waste description is powdered resin, filters, and irradiated hardware. Waste classification is Class B and Class C. The waste form is stable and unstable. The volume is 725 cubic feet. Curies are 61,200, including 6,000 millicuries of C14, 80,000 microcuries of technetium-99, and 1.2 times 10 to the 10th nanocuries of I-129. And the expiration, or the agreement would be from today through August 31, 2015.
For the motion, is there a second? Okay, the judge seconds the motion. Are any questions on the motion, Mr. Salzman? Any comments? Ms. Haddon, I saw you get up earlier. Okay. Robert?
It's just good every once in a while to remind you about the still unresolved issue of what unlimited access for South Texas Project and Comanche Peak means in terms of maybe you giving away capacity. I know they've got a lot more capacity than they used to have, but still unlimited means unlimited, and would also assume it means unlimited access to some of the individual isotopes that this application may be taking up. Are you prepared to say that you're meeting the requirements of the law, and that if suddenly South Texas Project and Comanche Peak roll up with an application that you're sure there will be room for it?
Thank you. Any other comments or questions from any of the audience? Okay, I'm ready for a vote on the motion. All those in favor of the motion, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion approves, 6 voting in favor, chair not voting. Next, Duke Energy McGuire, Mr. Salzman.
Mr. Chairman, the technical committee has received and reviewed an application for import number 1-0076-00 from Duke Energy Corporation, McGuire Nuclear Station. And in that application, Duke McGuire is acting as a generator, requesting authorization to dispose of material in accordance with the Act. I would note that they are requesting authorization to dispose of Class B and Class C unstable dewatered bead resin, and that disposal was approved by TCEQ for the compact waste facility operator in a letter dated September 2, 2014. Duke McGuire is requesting 400 cubic feet, 1,800 curies, 3,000 millicuries of C14, and 40 microcuries of technetium-99. In this case, the materials will also be coming from the state of North Carolina. The applicant has no unresolved issues with the commission or with any other regulatory entity that we are aware of. And again, North Carolina is unaffiliated, so no import or no export agreement would be required. They have requested disposal for a period from September 1, 2014 through August 31, 2015. And the technical committee recommends approval of this application.
Any questions of Mr. Salzman? Don't hear any questions, so I guess I'm ready for a motion, John.
I make a motion that we approve the import agreement request 1-0076-00 from Duke Energy Corporation, McGuire Nuclear Station, signed July 31, 2014, and received August 1, 2014. The waste will be coming from the state of North Carolina. The waste description is dewatered bead resin. Waste classification is Class B and Class C. The waste form is unstable. The volume is 400 cubic feet. The curies are 1,800, including 3,000 millicuries of C14 and 40 microcuries of technetium-99, and the import agreement would be from today through August 31, 2015.
That's the motion. Is there a second?
Second.
Motion been made and seconded. Any questions of Mr. Salzman on the motion from any of the commissioners? Anybody care to comment here about this particular application? Seeing nobody desiring to leap up and enter the fray, then I'll call for a vote on the motion. All those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion passes by a vote of 6 in favor, no opposed, chair not voting. Okay, that's item 8 on our agenda. Next is Mr. Balzer, unless you want to delegate. Receive reports from WCS about site operations and anything else you want to tell us about.
I am happy to be here and report, and I am certain I will be delegating some of this in the future, so this is great. We did finish out our fiscal year for the 2013-2014, August 31st, so this would be full year numbers. We disposed of approximately 33,500 feet and 33,890 curies. If you do that as decayed, it's 33,140 curies. In compact waste, that was the total amount in and out of compact. In compact was about 6,200 feet and 1,140 curies, 1,070 curies as decayed. And I had no other items to report, but I'm happy to answer any questions. I can. So for total, volume was 33,500 feet and 33,890 curies. Our license has us account for those as decayed, so that number was 33,140 curies. And then in compact, just Texas and Vermont, it was 6,200 feet and 1,140 curies, 1,070 as decayed. Mm-hmm.
Can you just send a breakdown of that to the
I can.
commission?
Yep. I think Lee may have it, but otherwise we will send it to you.
Well, no, and we get that, and the big disposal report that has all the numbers in it,
Yeah.
but it might be helpful and an easier read to
Yeah,
just
have
send
the summary.
exactly what you said. Yeah, that might be helpful, thank you.
John?
How did everything go with the steam generators and all that?
They went fine. We have, as somebody noted, there's been a lot of rainfall out in West Texas, so that did slow putting concrete over them, but they're in the bottom of the disposal cells. And we have been pumping water out of the disposal cells. As I think everyone's aware of, they're virtually impenetrable, so the water just sits there until we pump it out. And so we have restarted disposal operations and restarted building the forms around it. And we're hoping it's going to stay dry. They have had water, it seems like, about every 2 weeks, just gully washers. So,
Is it safe to assume the generators didn't float up?
they did not. They stayed right where they got put.
I'm just interested in the water issue. I take it you've had an awful lot of rain, an unusual amount of rain recently. How does that work? Can you, what do you do? You say pump it out, I mean.
Sure.
How does that all work, and what do you feel is safe or unsafe in terms of water, standing water?
Yeah, so to put this in context, I think we had like 4 inches of rain in a period of 2 hours. So it was a tremendous amount. And out there, it looks fairly flat and level, but it just runs off. It doesn't really have a chance to soak into the ground, and so it just runs off. And so our landfill's built so that we have basically a diversion berm around the side of it. And that ditch, so any water that comes into the landfill from the sides is caught into that ditch. And it is designed to hold the 100-year flood. And then within the landfill itself, where the actual waste is, we also have it sloped with pumps and things like that so that we can collect rainfall as it comes in and pump that out. And so we have license criteria in our license that we have to pump that out in certain amounts of time, and where we can do disposal operations and things like that. And so we try to get it out of there as soon as possible. And typically that is within a week that water is pumped out and it is dry. We have that for both our compact and federal facilities. Obviously we have other facilities on site as well. Once that water, if it's non-contact, it goes into an evaporation pond. If it is contact water, where it could have come into contact with waste in the landfill, it goes into tanks. It then goes through our wastewater treatment facility. It's then sampled to make sure it's passed all the criteria, and then it's discharged into an evaporation pond. So all of the low-level facilities are zero discharge. So that water does not leave the site. It doesn't leave our evaporation ponds.
More questions, Dick?
Well, I guess can you kind of paint a picture of what it's like right now, for instance? I mean, if somebody went out there, would there be a lot of standing water? Or
No, for the compact facility, we actually got in there yesterday and did disposal. And so we had, I think, 6 liners that were in storage waiting on the water to get pumped out, and those were all placed yesterday. And so the compact landfill, at least, you will see it as dry. I'm sure the non-contact ditch probably still has water in it. We're probably still pumping that. We try to pump the contact water first out of the landfill that could come into contact with the waste, and then the ditch is secondary after we get that one done. But the water is contained.
Have you noticed any increase in your water levels in any of your wells?
No, I did hear the comment this morning, so I checked with our hydrogeologist on site, and that pumping rate and things have stayed the same for those that we are pumping, and none of the other wells we've noticed a difference.
All right. Any other questions from any of the commissioners? Because I had just a couple of questions about, are you operating under the procedures from TCQ about bringing in the so-called exempt material and putting it in your RCRA?
We are.
And who do you report to about the volumes and the nature of that material? Do you report that to TCQ?
We do. We've got, as with low level, we've got certain state fee reports and things associated with that landfill, and that gets reported to TCQ.
Okay. All right. Thank you, Rod. If there's no more questions, Peter, you look like you might have one. You're formulating one.
I'm not sure I know enough to ask a coherent question, but in terms of the permits that you have from TCEQ, are there any limits as to amount of radioactivity in the RCRA site, curies or cubic feet?
Yeah, absolutely. So in the on the RCRA landfill, it's limited by isotope. Generally, it's about 10% of the Class A limit, and that can vary by isotope. But what we did for the exempt landfill, you may recall for the compact and federal, we did a performance assessment. It includes the source term inventory and geologic characteristics, things like that. We expanded that to include the RCRA landfill as well. And put a specific source term in for the RCRA landfill, and assumed certain volumes of just exempt waste in that RCRA landfill. and then ran that model out. For NRC, that they required you to be less than a few millirems. TCQ required us to be more stringent and be less than 1 millirem. And then in addition, we've added to that certain operational constraints, such that only radiation workers are working in that landfill. It used to be you didn't have to be a rad worker because it was a hazardous waste landfill. But basically we're treating that as if it were a radioactive waste landfill at this point, to be an abundance of caution.
Dick?
The question of security was raised, financial security was raised by Representative Burnham, and I'm a little rusty on it. It seems to me that what Valhai was, I take it either is no longer, or it was sold or something. So
No.
what kind of security do you have, and what do you understand you're securing?
So just to clarify and make it simpler, as of a couple of days ago, our financial assurance mechanisms got revised. As you may recall, we had a major amendment that reduced our financial assurance mechanisms to around $85 million. That was financial assurance just for our low-level disposal facilities. It doesn't include our RECRA facilities. There's additional financial assurance for those. But for the financial assurance on the low level, there used to be some stock mechanisms and things like that. Those are now gone. So it is all just done by a bond. So it's a straight financial bond.
And somehow it sticks in my memory that and I may be completely wrong on this, but this has to do, I take it, with assuring essentially neighbors against environmental damage, except it stops at the state line.
No, this is if WCS, for some reason, WCS went bankrupt and decided in the middle of the night, we're done. It would assume we had rains similar to what we've had over the last few months. It would assume all our inventories are full and storage is full and this and that and the other. And this would provide the funds for the state of Texas, TCQ, to come in, hire a third-party contractor, and clean up the site. And so they would close the landfill, they would do the post-closure monitoring, institutional control. There's a corrective action that is funded as well in case there's an accident after closure happens. But this allows the state to use a third-party contractor in a worst-case scenario to go and close the site.
And is the amount of the bond the result of some kind of studies, or?
Yeah, there were detailed engineering calculations that determined what it would take for a third-party contractor to come in, how much soil to move, and things like that, and then cost that out.
I mean, 85 million in your business sounds a little bit thin to me.
It sounds really hefty to me.
That's all right.
Okay. Mr. Harley?
Rod, back to the reports that you provide TCEQ in relation to the RECRA landfill. Could you provide us a little detail on how those reports are broken down? Does it specifically address the amount of exempt waste that's taken into the RECRA facility?
Not to my knowledge, and I'm getting on kind of the edge of my knowledge, but I'd be happy to get somebody who knows more about it in touch with you if you'd like.
Okay, that would be nice. Thank you.
Before you leave, you mentioned the performance assessment, and I'm curious about that. You said you expanded the performance assessment, and my question is, does the performance assessment look at the facility as one collectively assembled source term, or do you look at it separately by individual functions and then separately model those and do the addition after each of the simulations is done?
And again, we're stretching my thin ice here on technical knowledge, but my understanding is we actually do it both ways. We have a specific inventory for the compact, a specific inventory for the Fed and for the RECRA landfill, run those all together in case there is some kind of combined impact from all three, having those inventories together, and determine if that meets the standards, both all individually as well as collectively.
Is your byproduct disposal area also included in your performance assessment?
I would have to get back to you on that unless TCEQ knows off the top of their head. I don't think so. There
How do
hasn't
you
been
con-
anything put in there since Fernald.
Well, I understand that, but I mean, my question is and I've asked this question in other forums, is just a question of, okay, then is that additional radioactivity present at your total facility operation that's not included in the performance assessment?
That would be inventory that wasn't in our low-level performance assessment. It would be in our byproduct application, but regardless, the significant pathways and things like that, the collective really isn't coming into play through that.
And we're operating sort of in the dark because we don't know much about your performance assessment because we only look at the compact facility, and when you're looking at a performance assessment for a much bigger facility than just a compact, I'm curious, this is just me, about how that all works.
Yeah, we look at a variety of different pathways. The one of which is usually the driver is an intruder resident. They come onto a landfill, they drill a well, they try to pump water out of that well. We do have a monitoring zone, 225 feet deep. You can get a couple of liters of water out of there for sampling in a quarter, but not enough to really sustain it. We assume there's water coming out of there, and they drill a well into it, and they drink it, and they feed their livestock, they water their garden with it, and run that through our performance assessment. We also look at, diffusion, gaseous diffusion up through the cover system. It's a 40-foot thick cover. So we look at all those, and so that's why the inventory, for one, if you've got a well in a compact, you're probably not going to have a house next to it on the Fed, given that area and demographics.
Well, and that was one of my questions. I wanted to know whether the inputs are the same and consistent for all of the separate facilities as you look at them, or whether the inputs vary with each system, and then do you have a combined way of looking at the total input as if the site were just one thing?
Yeah, it is very consistent as far as methodology and basic inputs and things like that. Obviously, the inventory differs, and we haven't assumed that you have 3 residents on 3 different landfills out there at the same time, but our regulatory limit would really be what is that individual on any of those picking up. And so in any case, they all meet the regulatory limits, or are well below the regulatory limits.
Thank you. And I don't know enough to ask the questions that probably I would like to ask about this just from the health physics point of view, but I'm curious about some of this stuff. And so I appreciate your responding to my dumb questions. Anybody else? Thank you, Rod.
Thanks.
Robert.
What they didn't mention in relationship to the bond, from the question from Commissioner Sadek, was the fact that TCEQ significantly lowered their overall liability on the same day that they took the vote on tripling capacity with no public input, I might add. Look at it this way. If you traded in your Kia for a Maserati, you wouldn't expect the insurance company to significantly lower your bill, would you? 3 times the size, 3 times the capacity, and yet the total assurance is going to be lower. It just makes no sense to me. And secondly, I would just like to say, if WCS has figured out a way to filter radiation out of water, I think that the people at Fukushima would probably pay them a whole lot of money for that knowledge, as would many of the nuclear power plants that have problems with tritium in their groundwater. I didn't realize that you can filter radiation out of water, and I would be interested in knowing exactly why it's such a problem with plants that have tritium releases, tritium plumes under the plants.
All right. Thank you for those comments, Robert. That's agenda item 9, I guess it is. And next, that moves us to agenda item 10, update on the activities of the Commission's Fiscal Advisory Committee related to funding and expenditure of the Commission for 2014 and 2015 developments of legislative appropriation request to fund Commission operations during fiscal year 2016 and 2017. I'm going to ask Lee, do you want to talk to us about this, or do you want me to talk to us about this?
I want to do whatever the chairman wants to do.
I want you to talk
Okay.
about it.
We have submitted a legislative appropriations request to the Legislative Budget Board in advance of the next legislative session in Texas. The legislative session will begin on January 13th, 2015. That's a Tuesday. It will go through 140 days, which usually ends the end of May, very early days of June. And the pre-filing for bills, just as an aside, will begin this November 10th. Our legislative appropriation request that we submitted, we have been meeting with some of the leadership of the state of Texas about that legislative appropriation request, because the appropriation request is in line with the policies that affect state agencies. Yet we are not a state agency. And so we have a very unique situation that it is very important for the leadership of Texas and potentially the leadership of Vermont to understand, because both states are party states. And this appropriation affects how our commission would ultimately be funded, and even perhaps more importantly, the process we would go through to get that funding. This is early in the process to submit an initial LAR, legislative appropriation request. But there will be a lot of educating and meetings that we will be having with Texas leadership, and we will be working with our Vermont commissioners and potentially others in Vermont who may be interested, as directed by Commissioner Sadek and Commissioner Bradford and potentially Commissioner Saunders, as we move through the appropriation process to secure funding for the year 2016 and 2017. I can go into more detail as you'd like, but I'll stop there. Questions?
I want to set the stage for this because last meeting we passed a budget. And why don't you tell the members of the commission what the LAR is in terms of our budget?
Okay. What the legislative appropriation request is it takes the budget that you passed in July and turns it into a document that the state of Texas can understand. That is in the same format and the same nature of request as every state agency in Texas is. And the Legislative Budget Board, as directed by leadership, was told to tell all of the state of Texas agencies to base their legislative appropriation request on the budget average of the previous 2 years. If they wanted more than that as part of their appropriation, more money than that, they would have to make that an exceptional item, which is something that generally requires more discussion through a legislative process than the base budget. Even though we're not a state agency, in order for the Legislative Budget Board to take our request, we had to do the same thing. And so what that means is our legislative appropriation request asks for a little bit over half of the funds that you unanimously approved in July. As you can imagine, that is not. We are an independent, separate entity, and so we are talking with the House, the Senate, and the Governor's Office and others about what can we do moving forward so that we don't follow as an independent compact the same process that dependent state agencies do, and what is a good way to work effectively with the leadership of Texas and the leadership of Vermont. And to the extent the federal government requires the federal government to have a process that everybody feels very comfortable with. And we're beginning those meetings now to begin to get that moving. Did that develop what you were asking, Chairman?
Yeah, I wanted to add to that my understanding was that when Lee, using our good friends at the Board of Nursing, developed this legislative appropriations request, basically the software wouldn't accept it based upon our budget. The software rejected it because it didn't meet the Legislative Budget Board's software determinations for state agencies, which we are not, which is one of those interesting little things that we have to deal with. And Dick, I know that you're on the fiscal committee with me, but I try to insulate you from a bunch of these things. But part of the problem is that 100% of our current funding under the compact comes from a state of Texas appropriation. And what that means is the processes here in the state of Texas, even though our compact says we're not a state agency and everybody says no, we're not, well, except sometimes. This is one of those sometimes that we appear to be because they don't have any other way to treat us in the appropriation process. And so we get lumped into this, and this is just a problem that we're going to have. So, for example, and I've used this in discussions we've had recently, we in 2012 with the site open, we started learning a whole bunch of things, and we're now growing up in that. But basically, most of our funds are spent on travel for meetings and on Lee and Andre's salaries and a few other miscellaneous things that we do. But if we see the need to do more, we're sort of limited unless we can get some of these exceptional items through the legislature, through the budget process, and we might have to be faced with some pretty hard choices. And so I'm just telling everybody on the commission that so they know what to expect, because we're coming into maturity, and it's like any other adolescence, it's not easy. And so that's where we are. There's one other item in 10 that I wanted to specifically talk about, and that is that, and this has to do with my own personal thing. As you know, that as chairman, I get certain privileges. One of those is the privilege to write checks and approve expenditures of the Compact Commission. And right now, Mr. Salzman, I asked Mr. Salzman to take care for some of them, but most of them I pass on and I look at when we request for reimbursements for our appropriation. Currently, we're in good shape, but if we don't know what's going to happen starting September 1st of next year, and when we go through the next budget fiscal cycle. In that regard, we are required under the compact to do our own audits every year, and we've done one, and we're in the process of starting another one. But the comptroller also audited us, and that turned out to be a very interesting process, and I'll call it an interesting process because some of the same issues about whether we are or are not a state agency came up in the course of that audit, and I can give you some examples, but the one that I'm going to talk about is a request that the auditor made for reimbursement of a expense that I approved and was paid for a meeting. The first time, I guess, we went to Vermont in 2012, we all assembled for dinner, and rather than submitting separate travel expense requests for reimbursements, we just submitted one. The auditor of the state of Texas, and I'm saying this for the benefit of all the commission, requests that reimbursement be repaid. And in thinking about that, I knew that we had, and this turned out to be a good thing and a bad thing, and I'll talk about that in a minute, but I knew that we had some funds available in our bank account that was established before the site opened, when Vermont contributed funds to allow the Compact Commission to do things like hire an interim executive director and help the commissioners then prepare for meetings. We had some money left, so I said, we're not going to ask that the people that got this money get paid back. We'll just pay it out of our bank account. And again, because I have authority to write those checks, I wanted to make that known to everybody. It's a little over $1,000, as I recall, Lee, in round numbers. I don't know exactly what it is.
We've got all the documentation.
Yeah.
So much.
So what I'm going to propose to do, and what I have agreed to do, is to write that check to the treasurer of the state of Texas so that issue goes away. in terms of our state audit, because these funds are not available they're not in the state treasury. They're in our bank account. So I just want everybody to know that. So I'm reporting it publicly because I feel a little bit uncomfortable with and it was my fault. I did it. I made the offer to the treasurer. I said, okay, if you insist on doing it that way, we'll fix it this way because we have these funds available. I don't know what I would have done had we not had that bank account, but there it is. So I'm going to write that check to the state treasury at some point, and I haven't written it yet. And unless somebody raises a serious objection, I'll just state it that way, and I don't think anybody really cares because it's not the state of Texas money. It's really our money. Okay. That's all I wanted to say about item 10. Item 11, though, is respect to the bank account. Okay. And that I made the statements that I just did because of the bank account. When the state auditor heard my offer to reimburse them for our bank account, they said, "What bank account?" And I said, well, you're auditing our expenditures under the Texas appropriation. This one is not that. And that led to some interesting discussions. And to shorten that discussion, they had a suggestion that we terminate that bank account, which they now call, quote, local funds. And and under their perspective, it probably is a local fund. Under our perspective, it's not. And they further made the suggestion that after I write this check reimbursing them, that 100% of the balance go to the state treasury of the state of Texas, which caught my attention because none of that money came from the state treasury of the state of Texas. And without going into all of the history of it, which I could do if anybody is tremendously interested, because I carried it in my head, and Judge, you and I are the only people who remember all this. But that money came from deposits made in 2009, 2010, after the commission was limited to its appropriation from the state of Texas to one just for travel. We had to do things like maintain an office and have a telephone system and that sort of thing. We had no funds to do that with. And so Vermont contributed money to us to enable us to function during those times, over and above the appropriation that was made by the state of Texas for travel and meetings. So when I looked at the balance in the fund and I traced down the deposits in our bank account, 100% of them, with some minor exceptions for interest on, it was an interest-bearing account, came from the state of Vermont, with one exception, and that is there was an appropriation that allowed us to recover travel expenses, and before we worked out the way to do that, we actually advanced some of those expenses from that bank account, and then that was repaid by the state of Texas under the appropriation. So the question is, I don't have any problem with closing the bank account. Right now, we don't need one. We don't charge fees. But I wanted to make sure the commission see what the commission thought, particularly the Vermont commissioners, about 100% of the balance of the account going to the treasury of the state of Texas to a particular account as recommended by the Texas State Comptroller auditors.
In that account, it will still remain the exclusive resource of the commission, I take it, the compact commission. The account doesn't trouble me, but having it disappear into other Texas uses would seem a bit eccentric.
Well, I brought the audit report. I think the recommendation is that it go into a particular fund in the Texas State Treasury.
It says to send it, it would go back into the fund. When you send in travel reimbursements, et cetera, it would go back, and you're reimbursed out of a fund, it would go back into that fund. It would merely go back into there. But what would happen to that is if it is not spent at the end of the year, then all of that goes, what is not spent goes back into the Texas Treasury. Yeah.
I don't know what the principle is here, but the principal in the bank account is like less than $3,000.
It will be after we pay this one bill, it'll be probably around two.
And it just seems to me that, I mean, $3,000 is serious money in Vermont. Nonetheless, seems to me that you just ought to apply it and be done with it. I mean, the state of Texas reimburses our travel expenses, and as you all know, having been up to Vermont, all it takes is one trip or two trips, and that's it. So it seems to me that it ought to go, and this also goes to the, I think, is the tremendous advantage that Vermont has being part of this compact. Having a place where it knows it can dispose waste and so on, and now it's more urgent than it might have been before it was decided that Vermont Yankee would be closed down, but it really doesn't bother me.
Is it a one-time thing, or is this going to come around again?
Well, the bank account exists, and it was funded, the last time we had any deposits with it, I think, was 3 or 4 years ago, except for minor deposits of interest. But at the time, this was prior to 2011, before Lee came on board and before we had our offices, we had a post office, a U.S. United Postal Services post office box in Austin, and that money for that came out of here. Plus our cell phone came out of here because none of the people involved at that time were in Austin. And so the bank account was actually established in Amarillo, and we got transferred it down here to the same banking institution in 2011, and it's resided there. I remember writing checks on the account because I had to take over doing that when I became chairman. And the last time I remember writing a check was in the spring of 2012 for some expenses that had occurred during the previous fiscal year that had terminated until the appropriation took place. I can talk about the audit and about trying to get all this history across, but it's a difficult thing to do. So basically, the comptroller doesn't want us to have a separate bank account. Now, we don't charge fees. If we ever charge fees, we would have a bunch of questions about what would happen to that money. But right now, we don't do that. So I'm not opposed for that reason. There's no reason to keep the bank account open if we're going to liquidate it, which is what the treasurer, the auditor for the comptroller wants us to do.
I mean, I agree with Dick. If all that's involved is what's in that account now, then we've already spent too much time on it.
Okay. I just, to feel comfortable myself, I wanted to have the commission specifically authorize me in a motion to close that account and to pay the funds as requested by the auditor. And so.
Okay, well, since we're from Vermont, I'll move that. I'll move that the account be closed, that the funds go to, as suggested by the auditor. I guess auditors don't suggest, but as decided by the auditor, and that with the understanding that the state of Texas contributes to our expenses and has contributed to our expenses way beyond what's in that account. And that's my basic reason.
Okay. I just want to say that from my perspective, closing this account now doesn't forestall for me the idea that we may need to have a bank account in the future. We might need to reestablish that at some point, and I don't think that cuts this off. This is just talking about this specific account at the Wells Fargo branch, Wells Fargo Bank. So Dick, you've made the motion. Is there a second?
Second.
Thank you. All right, the motion's been made in a second. Are there any other questions related to this item? And again, I could bore everybody here with the history about how all this happened. And unfortunately, I carry it around in my head. So, if there's Judge, John, okay. The motion's been made and seconded that we close the account and transfer the remaining funds after the reimbursement is made to the Treasury as in the auditor's letter or report. All those in favor of the motion say aye.
Aye.
Any opposed?
Aye.
Okay. There being, let me count those as 1, 2, 3, 4, 5. 5 ayes, 1 no. Chair not voting. The motion passes. Thank you. We can at least resolve that issue. I also want to report there are a number of other issues that in the, what's called post-payment audit of the Texas Low-Level Radioactive Waste Disposal Compact Commission. I think each of you has received a report of it. I have a report. It's now been officially published, and it's online if anybody wants to see it. There are a number of issues associated with it with which we still have problems, and we're trying to figure out what to do about that. So, and just to give you some examples, when we start to go out to try to find contractors to help us, when we talk about contracting with individual people, we are told we cannot use the state system for listing those because we are not a state agency. And yet, for this purpose, we're considered to be a state agency, which sort of, I guess if you're a state, you don't have to be consistent in the way you interpret these things, but it's a little bit bothersome to me. And so when we go out to seek requests for proposals of people, we put them on Craigslist because that's available to us. And then we send the specific request for a proposal to people who we know who might be interested in helping us out in those fields, because that's sort of what we have to do. And this is, when Lee was talking about some of the discussions we're having, this is a big part of the discussion we're having. How we operate, given the financing in the compact, and what it says versus the software and the processes that are available to the state of Texas, because we are supported right now 100% by an appropriation from the state of Texas. So we have to live within those frameworks. We're trying to figure all this out. So thank you very much. And that's items 10 and 11. And that's really kind of my report, which is item 12, except that I want to say I've been attending a meeting. I went to the Radway Summit out in Las Vegas, and some of the questions that came up today were very interesting in terms of the Radway Summit discussions. For example, there was a big discussion out there about Los Alamos National Laboratory and WHIP, and when WHIP might reopen, and what the cause of the problems were out there. And my understanding, and this is just based on my understanding of the reports, was they're still not sure what happened at WHIP to cause the original problem. Every time somebody suggests something, turns out that there's alternative theory. They haven't definitively come up with the problem, with the solution yet, or with the cause. I did learn that when they restart operations, which are projected at late 2015, early 2016, and Judge, you and I had this conversation, they will only be able to restart at about 25% of the previous volume that was in place for shipments to WIP shortly before the accident occurred in February of this year. And the reason for that is they're going to have to totally reconstruct the ventilation system down below in the WIP facility, and that's going to take considerably more time. So I have no idea, and Judge, you and I have talked about this, when Andrews County might look forward not being the interim storage facility for the material from Los Alamos and from WIP that got shipped over there. But that's not our purview. But and I know that you and I have talked about when that might be, and you've got an idea in your head, and I think my idea, your idea probably coincide. A bunch of other things that were going on at that meeting, which were very interesting to me, and some of which led to my questions today, Rod. Thank you for answering my questions about the performance assessment. So with that, that's my report. I do say that 3 of us are now projected to go to the Low-Level Waste Forum meeting at the end of October in Denver. And is that right?
Well, the 3 I understand to go would be Commissioner Salzman, Judge Dolgener, and myself.
I've also registered.
And there will be 4 of us going.
Well, we can't have more than that, or we'd have to post it.
Well, I'm not a commissioner, so we're okay.
That's right. So that's the current state of affairs with those upcoming meetings, and except for the ones locally. And Lee, I understand we may have a legislative hearing on our appropriation request, LAR, before the budget board. Is that right? Sometime?
There is absolutely no doubt we'll have such a hearing. To my knowledge, that date has not yet been set. Yes.
Things are getting busy already gearing up for next January. And it doesn't have anything to do with any of the substantive things. It just has to do with this kind of stuff that the state legislature goes through in advance, because it's a big organization. Okay, Lee, you're next.
During a previous meeting, the commission authorized me to seek a request for proposal and to contract with a consultant to develop an operations manual for our compact. In case something were to happen to Audrey and I, there would be a manual that others could use to keep the trains running on time. And it looks like we're getting very close to making a decision and getting that started. As a reminder, the scope of this is not only to document the procedures that we have in place now for somebody else to follow, but to identify potential procedures that we should develop that we haven't thought to develop. And so the issue that's been brought up today, for instance, about when we should send notices out as a courtesy through email, if we'd like to develop a policy on that, there'll be opportunities for us to look at what else we should be deciding on a number of things as we go through this process. So I just wanted to give you an update on where we are with that. I've already shared with you everything I can think of about the legislative appropriations request and budget and the session about to become upon us. The final thing that I'll mention is I will be on vacation October 7th through 14th, and then again in November 6th through 11th. I will have my cell phone and email with me, but I will not be looking at it as often. And I will be in a very different time zone. So just FYI. And then when I get back from that, I slide back in on November 11th for the pre-filing of bills that starts November 10th. And I will be staying, with very few exceptions, in Austin from then on to be here for potential hearings, et cetera, through the legislative session so that we can ensure that we're here to provide information and educate and have decisions made throughout the state of Texas legislative process. To the extent that ever becomes relevant in the state of Vermont, we would be happy to do the exact same thing there. And that concludes my comments. I'm happy to answer any questions you have.
Any questions of Ms. Ing? Okay. Next, we have our usual discussion and possible changes of dates and locations for future meetings. And in this regard, I wanted to say that we have received a request to schedule meetings at least through calendar year 2015, so everybody can note the times we're going to meet. It's not necessarily a request that we increase the frequency. My understanding is this came from WCS and their governmental representative, Mr. Drew, who's not with us today because she's out of the country. But they have requested we do that, and I'm not opposed to doing that. I think it's a good idea to schedule them that far in advance. It helps everybody, but I also realize the problem is it's a burden that's going to fall upon our Vermont members. And I don't know whether, I assume it would be easier if we had some dates for you guys to, or periods that we'd be meeting.
Crowd them in the winter.
Crowd them in the winter so that they're, I wouldn't mind doing that, and but I am raising that because this is something that we've discussed in the past, and we've done it probably a quarter in advance, or 2 or 3 months, or 6 months, but we've now got this request that we consider it for a calendar year through the end of next year. And I don't have any good feel. I'm going to turn this over to Lee because she's in charge of doing all this stuff anyway. And I'm just I just show up when I'm supposed to show up.
So it's my understanding that we are going to set dates throughout 2015, or?
That's what, I think that's what the request, and it's not an unreasonable request unless there's objection from the commission. I'd like to consider that. We don't have to do it today, of course. We could wait until we're having a meeting in November and December, and if you wanted to give your ideas to Lee to where we could do that, but I'm wondering if we ought to at least plan for a January meeting right today.
Okay, because and thank you for adding that, because what we could do is add a January meeting and then do some informal outreach with the scheduling of the commissioners, get a sense of if y'all want to set it, how tentative you want them to be, where you would potentially want them to be, if you want them every third Thursday or something like that, and then propose a schedule at the November meeting. And that way there would be some input as opposed to trying to make that happen right now. I'd be happy to do that once I have direction from y'all to frame it and what you'd like done. I'd be happy to do that.
That seems to me to be a reasonable way to approach it, and I'm seeing a whole bunch of people nodding their heads, so I think that's what we'll plan on doing. But next question is, and I will also observe that in terms of location, once the legislature starts meeting, we may have to meet in a place other than the state capitol next spring for those meetings, and I just want everybody to consider that. And because we're not sure. Sir?
Can we use TCQ?
Yeah,
I can't speak for TCEQ, but they're here.
I haven't started those discussions with TCEQ yet, but they've always been extraordinarily gracious to us to have meetings there. Another idea is potentially, since we're a federal compact, would we potentially want meetings at the federal building? So we're looking at options because there may be times that we would need to have a meeting and TCEQ has that room taken up. We've been very lucky historically, but we're going to try and open up some options so we can ensure there's a conveniently located meeting for us when we need space.
And speaking of that kind of thing, although it's out of place, I'll just say that we've also talked about the idea to ask other entities, perhaps even including NRC and Organization of American States, and Agreement States and people like that, to come have a representative speak to us at some of our meetings, and scheduling meetings a year in advance will give us an opportunity to do that also. So, okay, do we want to set a January meeting? Anybody have problems with any particular dates in January. Thursdays work good for most of us, I think. I happen to bring my paper calendar.
Mr. Chairman, since we have a meeting scheduled December 17th, would we be looking at a date in the latter part of January?
Probably after the legislature convenes.
The legislature convenes January 13th, Tuesday, January 13th.
How about the 29th?
That's fine with me.
I couldn't be here.
You can't be here. What about the previous Thursday, the 22nd?
Yeah.
You could do it the 22nd, but not the 29th. 22nd, okay, John?
Sure.
Judge?
Yes.
Brandon?
Yes.
Okay. Peter, Dick, 22nd, okay with you?
22nd is better than 29th.
Okay. I've got it written in ink on my calendar now. So,
And as a reminder, just so you know, we set these all as tentative meeting dates, and they are not finalized until the agenda is posted.
Gotcha, but we can begin to look at where we'd be meeting and the time and all that. And I assume that 9:30 works well as a beginning time for everybody. 'Cause this morning, it took me an hour and 15 minutes to get here, and I live one county out. And so,
Our next meeting is the 13th.
no,
That's
yes,
correct.
November.
That sounded like, did I get this wrong? It sounded like quite a jumble when you were reading of the November numbers. Yours plus the,
Our next meeting is set for tentatively November 13th, 2014. The meeting after that is set for December 17th, 2014. And the meeting after that is now set for January 22nd, 2014.
15.
2015, that's right. We get a new year. My apologies.
All right. Everybody good? I think that's the agenda. We're all here. Entertain a motion to adjourn.
Nothing?
No.
Did you have a comment you wanted to make?
well, just if I'll see about Jane's availability.
Okay.
Motion to adjourn.
I'm sorry.
Wait,
Well,
wait.
I'm just wondering if TCEQ has anything worth sharing with us about the RECRA process and facility.
He wants to know if you want to tell us anything about RECRA.
You've heard all the backing and forthing about the RECRA
Sure.
issue.
We permit the RECRA site, the license we issued back in May, the amendment we issued in May 2013 took care of the exemption amendment. I think it's all wrapped up as far as we're concerned.
Yeah, and you also, I mean, how to put this tactfully, about every meeting we have, somebody gets up and says, we want you to do this, this, and this, basically environment, health and safety related, because we're unhappy with processes of TCEQ, or we can't get information, or we can't take part in their proceedings. I just thought I ought to give you a chance to say whatever you'd like in response to that.
Well, I don't know that this is a forum to just thoroughly debate that. TCQ has.
Well, my sentiments exactly, but it does keep coming to us.
Sure. Well, and I don't know how you want to deal with that. We're comfortable with our public participation process. You heard people tell you today they didn't have the opportunity to participate. That's not accurate. They did. There were public comments given to us in writing, signed by people who said they didn't have an opportunity to participate. We had a commissioner's agenda. At that agenda, Representative Burnham, staff person, was given a chance to talk. He chose not to, and in that moment, there was a later action taken by the commission on a contested case hearing, and we never allow public discussion on a decision about whether or not to grant a contested case hearing, because all that's in front of the commission is the administrative record at that point, and nothing can be added to the administrative record before it goes to the hearing. And so it's just part of the agency's process, but it's well known, and there's a lot of public participation. We responded to comments on the contested case hearing request. There's a wealth of information there. I don't honestly know why people don't think they had the opportunity to participate, because some of them actually did. So.
Well, we're not the Court of Appeals, obviously.
Well, and I guess that's why I'm curious why I'm getting the question. But
well, because we keep getting the question, and I just want to have a sense of your take on.
Yeah. Well, I'm always happy to answer your questions. That's why we come even when we're not on the agendas, so that if you have a question you need to ask me, I will do the best I can to answer it.
We appreciate that.
I guess we're not adjourned. Go ahead, Dick.
Well, the impression that's conveyed to us, for better or worse, it may be a false impression, is that the TCEQ basically waves through what the operator wants. And I suppose it would be helpful if we had a kind of a feeling for how you've modified things, or particular applications of what's going on, whether it's a dialogue or kind of an active dialogue, or whether you've just stamped it, no, you're not going to get this.
It's a very active dialogue. And I don't think WCS would ever say they have a very relaxed environment at TCEQ to get their things approved. I think they feel like the regulatory boots on their neck all the time. So what I think it's important to understand that our work in the division dealing with license amendment is based on rules, and so we make decisions based on the rules that we've been given. We don't make policy decisions in looking at license amendments. So we look at the rules, we look at the science, we try and make sure the science is defendable. We also look at public health considerations in terms of using our best professional judgment as health physicists in terms of evaluating what's going on at the site. We have 2 resident inspectors that are there all the time, making sure there's compliance with the license. There's over 200 license conditions, plus appendices, plus all the waste acceptance criteria and waste acceptance plan. And so, we do not take lightly our responsibility as the regulator. I was the director of Water Quality Division. From time to time in the Water Quality Division, folks were unhappy with wastewater treatment plant that had been permitted close to their house. It's not uncommon for people that don't agree with the decisions that we make to criticize those decisions as being cavalier and uncaring. But they don't really know the people that work in my division. They don't really know me. They don't really ever talk to me. We're passionate about what we do. I don't want my granddaughters to have to change their last name. And so I'm not going to make a cavalier decision relative to that site in Andrews County.
Let me do this, and I've got whispered in my ear by my lawyer that
you're off the agenda, right?
Yeah, and if these questions, if the commission wants to address these questions, perhaps we should generate questions and put them on an agenda item to be discussed to where we'll all be a little bit better prepared and focused to talk about them, because right now we're inquiring about processes for general information of TCQ, which we could do under the agenda item 4, but that's been a long time ago in this meeting. So if nobody objects, and to save a lot of angst, what we'll do is just go ahead And Charles, we appreciate your coming forward to answer and enter into this dialogue with us, but I think we're better off telling you thank you. And I know you'd be willing to do that if we structure it. And
well, for the sake of the relationship, if you call me up here, I'm going to come up here.
I knew that.
I do fully understand Karen's concern.
Yeah, and so, but thank you for your willingness to do that and to keep us legal. I think Karen.
Let me just explain for those who may not understand. This is I would be the last one to want to cut off my commissioners from asking questions. I think this is a good dialogue, but the agenda item was much earlier in the meeting, and people who may be interested may have assumed there was not going to be any further discussion about it. And so we don't want to be, we want to be sure that everybody who wants to participate or hear that discussion is here to hear it. Now, looking around the room, I'm not sure I see that anybody's missing. But I really kind of don't want to gamble my commission's showing up in court to defend an open meetings challenge on it. That was my concern.
Are you referring to the agenda item that allows public comment?
No, actually, I wasn't, Commissioner Sodick. I was referring to the item about the RCRA exemption committee. But if we're not even under that topic, I'm even more concerned.
And when she first whispered in my ear, I said, well, this would be germane under agenda item 4, and she said that was a long time ago, so that was the reason I raised it too.
Well, I just might say that I have no problem with putting it off or asking, written questions or whatever. But since TCEQ isn't directly on the agenda, it strikes me that saying we've covered it in the agenda is not entirely correct.
Well, and that's exactly the problem. If they're not on the agenda, our talking about it is
not on the agenda.
We need to let the public know if we're going to talk to the TCEQ about their procedures related to this, is what I'm saying.
Let's not belabor it.
All right. Thank you, Charles.
Thank you.
I move that we adjourn.
Second.
I think we're adjourned.